Peter Glazer, a partner with the law firm Troutman Standers, will help us understand an upcoming case in the United States Supreme Court to be argued on April 19th. Peter, tell us a little bit about the American Electric Power Company versus Connecticut case. What's the case about?
Sure. In AEP versus Connecticut, the court will determine the question of whether emitters of greenhouse gases can be sued under a common law tort theory. 8 states, the city of New York, and a number of environmental organizations sued 5 electric utility companies claiming that the greenhouse gas emissions from the utilities' coal-fired electric generating stations contribute to global climate change. According to the complaint, running these generating stations and emitting greenhouse gases constitutes a public nuisance actionable under federal and state common law. The plaintiff sought an injunction requiring a reduction of these emissions. In 2005, the district court granted motions to dismiss the action on the ground that the case raised a non-justiciable political question. Quoting a statement by the Environmental Protection Agency that, quote, "It is hard to imagine any issue in the environmental area having greater economic and political significance than regulation of activities that might lead to global climate change," unquote. The court found that it could not adjudicate the complaint without resolving fundamental issues of economic, environmental, foreign policy, and national security interests. According to the court, these policy decisions are matters for Congress, not for the judiciary. In 2009, however, the Second Circuit reversed. The Circuit Court rejected the district court's reasoning regarding political question and also rejected other arguments raised by the defendants, including standing, failure to state a cause of action under nuisance law, and displacement. The displacement argument is that any federal common law that might govern greenhouse gas emissions is displaced by greenhouse gas regulation now being undertaken by the Environmental Protection Agency under federal statutory law. All of these and other issues will now be decided by the Supreme Court.
Are there other similar cases pending of this sort?
Yes. AEP versus Connecticut was the first of 4 cases seeking to hold greenhouse gas emitters liable in tort. In the other 3 cases, the district court, as in the AEP versus Connecticut case, granted motions to dismiss, either based on the political question doctrine or on the standing doctrine, or both. One of these cases was subsequently settled. One was reversed by the Fifth Circuit, with that decision then vacated en banc without a decision on the merits, and then the Ninth Circuit case, the third case, is pending before the Ninth Circuit now.
Why is the AEP versus Connecticut case significant beyond just this case itself?
Yeah, whether and how greenhouse gases should be regulated has been a hotly contested area of American public policy now for more than 2 decades. Although there have been numerous bills in Congress to regulate greenhouse gases through, for instance, a cap-and-trade program, Congress has never enacted legislation explicitly requiring greenhouse gas controls. In its 2007 Massachusetts versus EPA case, the court found that Congress had, without realizing it really, authorized greenhouse gas regulation under the Clean Air Act, and the court found that EPA could regulate greenhouse gases if it made the prerequisite endangerment finding. EPA then made that endangerment finding and has proceeded with greenhouse gas regulation, although there are now bills in Congress to stop EPA from doing so. AEP versus Connecticut now raises the prospect that greenhouse gases will become regulated in the United States by judges and jury under tort law. Keep in mind that 85% of the energy used in the United States comes from fossil fuels, and greenhouse gases are the inevitable byproduct of combusting fossil fuel for energy. If the court affirms the Second Circuit decision, then most energy companies will potentially become subject to suits in damages and for injunctions, essentially because they utilize fossil fuels. If these suits are successful, the courts will become the arbiters of the type of energy America uses and how much we as Americans pay for energy.
Any thoughts on how the Supreme Court might rule?
Yeah, we may very well see the same split that we have seen in other cases between the liberal and the conservative wing of the court, with Justice Kennedy, who was the key swing vote in the Massachusetts versus EPA case, again being the swing vote here. Justice Sotomayor has recused herself from the case because she was actually on the original Second Circuit panel that heard oral argument in the matter, although she subsequently withdrew from the case while it was still before the appellate court when she was nominated to be on the Supreme Court. There was some thought that Justice Kagan might recuse herself to the extent that she concluded that the Solicitor General's office, which is representing one of the defendants in this case, might conclude that she had been actively involved in the case during her tenure in the SG's office. She did not recuse herself, however, and so 5 votes will still be required to overturn the Second Circuit decision. And to show how political this case is, of the 8 states that had originally been plaintiffs in the case at the time the complaint was filed, 2 of those states have since withdrawn from the case, have withdrawn as plaintiffs since Republicans were elected as governors of those states in the 2010 elections.
Thank you, Peter. The Washington Legal Foundation filed a brief in the AEP versus Connecticut case, which you can find on our website, www.wlf.org.